Any mention?
May please, Your Lordship. Item 31, 32, the hearing list, Your Lordship.
Upgrade.
31 and 32.
Don't upgrade it.
Yes.
Huh?
On that till after winter vacation, Your Lordship.
Oh, after winter vacation, I thought you wanted to upgrade the matter. 31, 32.
Yes, sir.
Ramon Mukim.
Yes.
You have no objection?
No objection.
Yes.
Obliged.
May I please, Your Lordship? I beg to mention item number 36.
Yes.
Let the matter may come after
Yeah,
the
no objection.
vacation.
Okay,
Till
that's it.
44, my lord.
Till 44 is connected.
Till?
44. 36 to 44.
Who did the case? Mr. Nath?
Yes.
What did it come for?
My lord, that encroachment in the nation.
No, no, it's ready for hearing. Where's Mr. Nath?
He's out of station, my lord.
Otherwise, this batch matter will finish it off. Anything remains here.
No, my lord.
It's a short point. Who's the other counsel here? SR Marak.
It is me, my lord.
JFGH Mo Pinyang.
My colleague.
Soon.
This matter pertains to the encroachment to the
I understand, yes.
national highway.
Why taking adjournment?
He's out of station, my lord.
Encroachments, if it's affecting the road construction and development, then that cannot be kept pending.
It's not affecting, not,
Not affecting?
no, not at all.
Then it's fine. Yes, after vacation.
Notification.
DP.
Your
Yes.
Lordship, I beg to mention item number 30.
Number
30, Your Lordship.
30.
Yes.
No objection.
No objection. Yes.
Me please, Lordship. Lordship, beg to mention item 34, my lord. 34.
Yes.
Lordship, I'm the respondent in this matter. Slight difficulty today, my lord. If this matter can be taken later in the week, my lord, subject to convenience.
Small matter, Your Lordship, because why? For the 50% dead release, this is the oldest MSCD case pending. 50%
Tomorrow.
day after tomorrow. Much obliged.
Yes.
May I please, Your Lordship? I beg to mention item number 35, Lordship.
45.
35.
And similar prayer for 45 also, Lordship.
Which you're mentioning 45 or
35 also, Lordship.
35?
Yes, Lordship.
Oh. No objection.
No objection, yes, Your Lordship.
Okay. Yes.
Similar prayer for item number 45 also, Lordship.
Number?
45.
Already this.
Yes, Lordship.
Noted, yes. 36 to 44, 33.
May I please, Your Lordship? Your Lordship, I beg to mention item number 33, Your Lordship.
My lord,
Yeah,
this
objection?
yes, Your Lordship, because this execution proceeding has been stay against that I have approached this honourable court. Otherwise, this honourable court, my lord, can pass us order to complete the execution proceeding within a reasonable time.
Where's your senior?
He's not keeping well, Your Lordship.
MS Panjom and Miss Sinkan. Where's he?
Mr. N. Sinkon, he's not keeping well, Your Lordship.
He's in the court.
No, Your Lordship.
Then day after tomorrow.
After vacations, Your Lordship.
After vacations. No, I will try next week then. 16, okay?
Yes,
You have 1 week.
Much obliged, Your Lordship.
Is objected to, we will not give them easily, yes.
Obliged.
Yes.
Please, Your Lordship. Lordship, I beg to mention item 27.
Yes. On whose behalf?
V. Kumar, he's having personal difficulties. No objection, Lordship.
After vacation, yes.
Obliged.
Item number 1.
Can I take up this matter?
Lordship, it's up to your Lordship.
Long time ago, I think.
Yes, Your Lordship. I think in TS number 990, there's one TS title suit number 1990. Lordship, Your Lordship is part of that.
Yes, I was.
I think Your Lordship was part of that suit.
90, it stems from the same one.
Yes, my lord.
Then let it go some other time. Let's go in the bench or me.
Item number 2.
What is this, Dr. Mazika?
My lord, here what happened, my lord, some arbitration award was passed and we challenged that award, my lord, before the Judicial Court, my lord,
It's under the old Act and new Act.
under the new act, my lord.
Okay.
Now, our challenge, section 34 was dismissed for default for some reason, my lord, in around 2020 when I resigned from CCC at that point of time. So, now, what happened, my lord? They filed execution petition. The learned trial court has proceeded to execute the petition. Section 34 was subsequently restored also. Now, while section 34 is pending, the learned court has allowed the withdrawal of the amount, 50% on furnishing bank guarantee and 50% on indemnity bond, my lord. Now, indemnity bond is nothing, my lord. It cannot secure the amount. Indemnity bond is simply signed by the person himself. So, against that order we go. But there is some delay in coming, my lord. The order was passed in the month of April itself.
Then you have the case for condemnations there.
Well, we have come under 227 that.
Understand, but even then, it's reasonable period you have to explain.
And only if the notice may be issued, my lord, at this stage.
Noticeable issue, yes. But Dr. Mozika, senior counsel with MS Arguru for the
K group.
petitioner. How many respondents are there? One petitioner, one
There are
respondent.
two respondents.
Issue notice returnable in 3 weeks. Notice to be taken by ICD within 2 days, yes.
Obliged.
Item number 3.
This matter may come up with item number 19, my lord. The item number 19 is a writ petition, connected matter, my lord.
And take it together at 19. When 19 comes, I know when. Yes.
Item number 4.
Please, Lordship.
1 second, let the file come. Yes.
Lordship, the petitioner is an employee of MECL and is aggrieved, Lordship, by the pendency of the departmental proceedings, which has been delayed for.
Department, where's MECL? Where's MS Colney?
Lordship, we're trying to serve copies, but he said that.
Why not taking copy? Selectively, you take copy.
My lord, we have instruction that they have to serve the copy to the office, my lord. Thereafter, we have been assigned the matters. We are in a panel.
High stake matters, you take copy instantly.
No, my lord, high stake matter is the matter which I don't
person who's coming in DP, you want him to go to office.
My lord, I'll take notice, my lord,
Then?
in that case.
Yes, let him take notice.
Yes, Lordship.
Yes, heard Mr. Krang, then it comes to the petitioner. Only against the non-completion dispute proceedings.
Yes, Lordship.
Yes, issue notice, MSR Colney, self notice on behalf of all the respondents. No further notice required just after 3 weeks for just after vacation for instruction affidavit. You believe in Article 14, right?
My lord, yes.
Then show equality to all matters also.
My lord, we are assigned, my lord, as per cases, that's why, my lord.
Yes.
Maybe, please, Your Lordship. Your Lordship, this is against a suspension. The
Where's
suspension.
the respondents?
We have served notice, Your Lordship. Means suspension is non-as of today, Your Lordship, because initially 90 days
Non-as
given.
meaning?
Non-as means they have not extended further.
It was still when?
It was till November 5th. First, Your Lordship will come to page 55, if Your Lordship. page, Your Lordship, this is a suspension order of 8 May 2024.
55.
Then thereafter, Your Lordship, annexure 10, the extension. Your Lordship will see first. He's an executive engineer, Your Lordship, of NEHU.
Yes, and yes.
Then next page is 56, Your Lordship.
56.
56. In portions to the 82 emergent executive council decision resolution so-and-so, Jose Cherian, executive engineer, NEHU is extended for 190 days afterwards, 6 August 2024. So that expired. November it expired. So now there is no suspension. So my prayer that the suspension is illegal, and I may be allowed to reinstate because I'm going to retire.
Why is this illegal?
Suspension is illegal because
any proceedings are
yes,
pending now.
Proceeding
Has been drawn up. Many proceedings been drawn
it
up.
has been drawn up, but no inquiry officer, nothing has proceeded.
When were they drawn up?
It was drawn up on 8 May.
Since 8 May, nothing.
Nothing.
No
nothing.
statement of charges. No.
No
statement
charges
allegations,
they given, but we have given the show cause, but nothing has been done till today. So, and I'm going to retire on 30th June 2025. So my pension paper required to be prepared. So I may be reinstated, and because whatever documents there is allotment of work, tender work.
Pension papers will take 6 months. So from yes, Mr. Sen, what is this?
I'll file my affidavit. Affidavit, Your Lordship.
Yes.
I'll obtain instruction and file it.
Listen next week.
It may come up, my lord. I'll file it immediately after vacation, first week.
And inevitably, I may be allowed to reinstate because unnecessarily I'm
have
hanging.
to pass interim orders. We'll give you a chance to come with instructions. We'll give you maybe 2 days, maybe on Friday come back with instructions. Otherwise, we'll have, then will you reinstate him?
Reinstate and let them prepare the pension paper.
It is a time-bound suspension order. It's not a question of indefinite.
No, I understand. I understand what you
Right.
said.
So I mean, if it's lapsed, that means if there are no orders in operation, that means by rights he's got to resume his duties.
I'll obtain instructions.
By when? Tomorrow?
Tomorrow. Give me some time, Your Lordship. Next week then.
The next week, 16th?
As you
Yes.
But 16 Your Lordship, because some matter is fixed already. So can we earlier 13 Your Lordship?
13th, okay.
13th.
Heard Mr. Esmanta, Leonard, senior counsel with Mr. L.M. Sangma for the petitioner. Issue notice, Mr. S.N. is present, except on behalf of both the respondents whom if necessary. Stop next part of the then senior counsel submits that the matter concerns the suspension of the petitioner, which has since lapsed by virtue of the order dated that they settled 6 months.
Yes.
Virtue of the order dated
August, 5th August.
5/8/2024. Stop. He submits that in view of the fact that there is no suspension order operating at the moment, directions be issued to allow him to resume his duty. Stop. Next one is sent to obtain immediate instructions. List the matter on Friday for further orders. Yes.
Deputy.
Item number 6.
May it please Your Lordship. May it please Your Lordship. Well, this is the read petition, my lord, against an order.
There's a caveat.
There is a caveat. I have solved the problem.
Yes.
No, my lord.
Another tourist spot also you've come now.
No, this is not a tourist spot.
Another tourist spot, Nongjorong village. Okay.
All these cases now.
No, my lord. What happened in this?
You're appearing for behalf of the village.
Village, yes, Your Lordship.
Respondent.
Respondent number 6.
I have served a copy.
You already served. Yes, it's seen a caveat petition filed by the respondent number 6, caveat, who is represented today by MSPS Nongbri. Accordingly, caveat stands discharged. Yes.
Well, this is against an order, my lord, of the executive committee, my lord, passed in a political appeal.
Passed?
In the political appeal, Your Lordship, dated, my lord, 11/11/24, Your Lordships. Now, my lord, briefly, if I can just narrate the facts, my lord, that's important. Now, my lord, there was some boundary dispute between two villages, the writ petitioner villages and respondent number 6, my lord. So that issue was resolved, my lord, by the Elaka, my lord, the Siem of Karim, my lord, and his Darbar, way back in 2017.
This dispute was settled in 2017.
17.
The boundary dispute.
Boundary dispute settled. Now, thereafter, my lord, this is entire thing is governed by an act, my lord, that Administration of Elaka Act 1991 and legislation made by the District Council pursuant to paragraph 3. Now, these contains, my lord, these are all statutory proceedings, my lord. 5 and 6, my lord, section 5 and 6 of the act, my lord, contemplates how it is to be dealt with. If it is a dispute within the Elaka, two villages within the Elaka, this is to be resolved by the Elaka, my lord. And then, if any party is aggrieved, an appeal will lie before the tribunal, one-man tribunal, my lord. The requirement is further that it has to be filed within 30 days. There is no provision as such for condonation. Now, what happened in March? The matter was resolved by the Elaka, your lordships. Now, against this lordship, ultimately, after 2 years, a writ petition was filed before this honorable court, seeking condonation of delay of about 580 days. My lord, I'm sorry, your lordships. Now, what happened thereafter, my lord, almost after 2 years, an appeal was filed before the tribunal. Now, the tribunal, my lord, if I can take my lord to that decision of the tribunal, that is at, my lord, page 51.
Yes. 51.
Page 51. Lordship. No. This was filed, my lord, almost after 580 days. Now, this is 16/4.
It was filed in 2019.
19. The issue was resolved in 17. This was filed in 19. Now, what is the order passed by the tribunal? On perusal of the appeal dated such and such, filed with the Sadar Kut village against the order of Sema Khairim and his Darbar dated 2nd March 17.
It was filed by respondent number 6.
Respondent number 6. It transpired that the appeal is not laid down in the proviso to section 5(2) of the Khas Hills Autonomous District Elaka Act 1991, an extract of which is reproduced hereinafter. But the entire provision has been reproduced. Boundary disputes. If any boundary disputes arises between the
two. Rejected on 16 April without delay. Yes.
Lordship.
What happened after that?
After that, my lord, a writ petition was filed before this honorable court, realizing, my lord, that this delay cannot be condoned, my lord, not even by the executive committee. They were conscious of it. And they filed a writ petition, my lord. And in the writ petition at page 57, my lord, the order was passed at page 57 of the Honorable High Court. My lord. That is dated, your lordships, 3/7/2019.
Yes.
Now, the petitioner invoking the jurisdiction of the court under Article 2 to 6 of the Constitution has impugned the order dated 16/4/2019, passed by the respondent tribunal.
They withdrew.
And they had withdrawn, my lord, with the liberty to pursue the matter before the civil court, whatever remedy is available.
Yeah.
Now, after that, what happened? They approached the civil court, filed a title suit. In the title suit, my lord, we enter appearance. We raised, my lord, preliminary objections with regard to the maintainability. After hearing the parties, my lord, the suit was dismissed. Against this
order of dismissal.
Lordship, right come.
On next page.
My lord, 58.
Yes. It was filed in 19.
19. My lord, the operative part will be, your lordships, at page 68.
On ground jurisdiction is dismissed.
Perusal of the acts of the court formed opinion that the court is not appropriate for it to adjudicate the instant suit and has no jurisdiction to entertain and try the instant suit under the provision of the. Therefore, the instant miss case numbers allowed and the title suit number hereby rejected for want of jurisdiction.
Yes.
So that was dismissed, my lord. They next page, your lordship, they prefer an appeal against the order. Now the appeal too was dismissed. Lordship will, my lord, operative part will be, your lordship, at page 94.
94.
94. The appeal is now made for consideration and it is hereby dismissed.
Yes.
Now, my lord, the next page, page 95, now they come up back, my lord, and they file under 5(3). Now, 5(3) provides for an appeal from the order or decision of the administration before the executive committee. Now, they file an appeal.
Against the order of May 19.
May
why the appeal was rejected before the tribunal.
No, initially what they did, my lord, they approached the executive committee, filed an appeal against the original order passed by the Elaka head, my lord. That is in 17,
yes.
not of the tribunal, not of the tribunal. So, my lord, the executive committee, my lord, on the ground that this should have been against the order of the tribunal and not against the order of the Darbar, my lord, rejected the appeal with a liberty, my lord, that they can come back for an appeal before the executive committee against the decision of the tribunal. So, my lord, they have thereafter, my lord, filed yet another appeal, my lord, after making necessary correction. My lord, that appeal is at page 102. Now, this is against the order of the tribunal passed in the year, my lords, 2019. Now, in the appeal, I entered appearance. So, my objection, my lord, main objection was, this is not a common law remedy, my lord. This is a statutory proceedings. And once it is a statutory proceedings, we are strictly governed by the statute. That is by the Ilaka Act. And Ilaka Act, there is not a whisper anywhere, my lord, that any authority has a power to condone any delay. Instead, my lord, the proviso to 5.2 is very clear and categorical that beyond 30 days has to be filed 30 days. So, by clear implication, any appeal filed beyond 30 days, my lord, is not maintainable, cannot be entertained. So, what the order passed by the tribunal, my lord, in 2000 is very correct. He is referred to 5.2 and said we cannot entertain it.
Now what's happened now? What
Now, my lord, in spite of the objection, my lord, the impugned order was passed. Now, impugned order is at page 123, Annexure 14.
125.
123, man.
Oh, 123.
Lordship. Political appeal number session dated 11/11/24. The instant petition came up before the executive committee being aggrieved with the order of one-man tribunal, boundary case number 1 of 2019, who rejected the appeal on the ground that was not filed 30 days period. Earlier in boundary case number 1 of 24, the executive committee has also afforded the petitioner a liberty to for fresh appeal as their appeal was not maintainable in that instant. Heard the learned counsel on behalf of the petitioner who submitted that they have now appealed before the executive committee under section 5 subsection 3 of the administration of Alaka Act 93 should be 91 to set aside the impugned order dated 16/4/2019 passed by the one-man tribunal in boundary case number 1 of 2019 and to condone the
You
delay.
appeared there also?
Lordship?
You appeared before this committee for that time?
Yes, appeared.
Yes.
1 of 2019 and to condone the delay as they have not been sleeping in the case but have been actively pursuing it. Learned counsel on behalf of the respondent submitted that the case has assumed finality as the petitioner has failed to file the appeal within the stipulated time. Moreover, the Act does not provide any power of the executive committee to overturn the order passed by the one-man tribunal. Having heard both the parties, the executive committee is of the considered view that one-man tribunal have dismissed the petition based on technical ground and the merit of the case had not been heard. We are also convinced that section 5
delay.
they condoned it. So my whole submission, my lord,
Have to seek
How?
instructions, madam.
What does the caveat have to say?
Section 3(5), Section 5, Clause 3, Your Lordship, it is categorically stated that any order of the tribunal, Your Lordship, can be appealed to the executive committee.
Exactly. Like any order can be appealed, but then if it's subject to, if it's a limitation and prescribed in the Act, in the statute itself,
And Your Lordship, there
how
have
can
been
you
many
beat that?
instances also whereby the executive committee has allowed, Your Lordship, even in this honourable court has many tribunal executive boundary matters, Your Lordship, where it has been sent back to the tribunal, Your Lordship. And
So
in this case, Your Lordship,
the thing is that in most cases is that when the matters come before this court, if they have not gone to the tribunal at all, that's a different matter. Then it's sent back to the committee to be put before the tribunal. That's different. This case, the appeal from as per 5.2, then with the order of this AM, it goes to the tribunal, and even filing in 30. After 2 years, he went.
Your Lordship, I may be allowed to file my affidavit because after the order of this AM was passed, Your Lordship, an application for review was also filed before this AM. That application was never heard.
Then was it ever discussed here in this order?
It was not discussed, Your
Then?
Lordship, but it is there in the records, Your Lordship. And
Let them file
secondly,
affidavit.
Well, there's been a change also. The Act has been amended. So that also has to be seen, because as per the amended provision, the powers of review also has been added. Early on, my lord, the power of review was not there.
But reviews will be subject to any.
Yes, yes.
my only thing, my lord, it can be, my lord, Lordship can decide the matter at the earliest. Let them file the affidavit. Now they have, my lord, issued a notice and all. In the meantime, let the proceeding be straight.
Yes, heard Mr. S. Senate Council Petitioner, if you notice.
I filed a mistake.
Mr. T.D. Rindol and its Senior Counsel with Mr. R. Arts present, accept notice on behalf of respondents number 1 to 5 and 7. as caveat been filed on PS Nombi's present behalf of the respondent number 6 stroke caveat. Notice to issue to the respondent number 8. It has been submitted that it has submitted by the learned counsel that the writ petition directed against the order, impugn order dated 27/11, 2024, whereby the district council respondents have condoned the delay in preferring an appeal against an order of the tribunal under the Administration of Ilaka Act 1991, which is submits is impermissible by law. Next submits praise that he made out to seek instructions and to file affidavit. Similarly, also the council respondent number 6. So when this is matter after vacations for affidavits and for further orders. It is next paragraph how it's provided that in the interim all further proceedings in what's the name of the case?
Proceedings, this impugn order has to be stayed, Your Lordship, 11/11/24, and the consequential notice at page 125.
It is provided in interim that the impugn order dated 11/24 and consequential order dated
27/11, notice, my Lord.
27/11, remains stayed until next date.
In political appeal number, my Lord.
Political appeal number?
1 of 21.
Item number 7.
Oblige, my Lord.
My Lord, item number 7 and 28, my Lord. These two are connected.
Mr. Kharshi, you file objections?
My Lord, regarding with
what about instructions?
My Lord,
Except,
this is a UP SAC government school of Meghalaya, government of Meghalaya, and she's also a sanctioned teacher. And can we come to
the review?
My Lord, page 109, my Lord.
109.
My Lord. This is the affidavit filed by the state.
Yes.
For G, my Lord.
Yes.
Mary, my Lord. The deponent for the begs to state that the district mission coordinator, Reboy district, Nongpo, White, letter dated 6/5/2022 informed the answering the deponent that the salary of the SSA school is released to the school managing committee and not to the name of the particular teacher by the block mission coordinator SSA, including Umling block. The salary of the Umtalan UPS SSA with effect from April 2017 till date has been released to the SMC bank account of the concerned school. My Lord, can you come to 115, my Lord, which is the annexures?
Yes.
Point number 2, my Lord. The salary of this SSA school is released to the school managing committee, not to the name of the particular teacher by the block mission coordinator, including the Umlik block. The salary of Tarlan with effect from April 2017 till date has been released to the SMC bank account of the concerned school, my Lord. To state that they don't have anything because he was
no, the
also...
thing is that, see, what they've stated is just a mercy petition, that's all. You understand? They've already paid that money to someone else. They deprive your client. Correct? So court has passed orders that whatever dues, they should pay you. Correct? To pay your client. Rather. Now they have paid you 1,90,000. Correct? Till date. And how much more they have to pay?
My Lord, it is coming to around 12 lakhs, my Lord.
12 lakhs. Now they're saying that even if we sell the whole village, they won't be able to raise that 12 lakhs also. So what are you going to do? So they said even contempt, you file contempt also, even if they'll go to jail also, but then they can't come up that amount. So that's why court is trying to work out some kind of via media that if you take a lesser amount, then we close the matter. Otherwise, it'll be impossible. They'll be held up for contempt.
Yes.
They can't. There's no excuse for them not to pay. The orders of the court is a judicial order. And number two, also what you're submitting, that is not disputed by them also.
Yes.
They've received the money, it's gone. They've paid some other teacher where you're not around. Now they have to pay the 12 lakhs, the contempt, we'll drop contempt proceedings, they'll let them go to jail, civil imprisonment for some time. But even that won't satisfy you. And he said that even if what he said that even if they sell the village, they won't be able to recover.
My lord, here it's a poor village, my lord, and it's a Dorbash Nong's school, my lord. Of course, the SSA teachers, certain teachers will come under the SSA, my lord. But now the management, the entire Dorbar is held up. We have to raise funds, and then 1,96,000, my lord, hardly, my lord, few thousands are left to repay the loan taken to pay her. So now what we are saying is with difficulty that also we are saying that 4 lakhs will give you, and within 3 installment within 6 months we will arrange somehow. Anyhow, we will ask anybody, agricultural products, whatever we pull up together, we'll try to help you in that way. So this is
you
what
can't
our
pay in
purpose is.
agricultural products, you'll pay in cash.
We will pay in cash, of course, my lord. You contribute something from the products and all these things, my lord. Broom, whatever products producers.
You've heard his offer. See, courts are sitting to decide the legal issue anymore.
Yes.
There is a review filed by them to review the order, which is course not inclined to review. The only thing that is up to the parties, if you can decide. Although it's around 12 lakhs you have to get if you can settle for and close the topic. Otherwise your clients, they know that they're liable for contempt.
Here, my lord, we have no escape, my lord. We have no escape. Of course, the present managing committee, my lord, the secretary, they understood the seriousness of the matter, but their hands are so tight, my lord. Even if little bit loose, also they can do something. They themselves, they are illiterate and cultivators, my lord. They themselves, my lord. It's very difficult situations, my lord.
What to do?
This is a government school, my lord.
It's not
She
a
is
government
also
school.
sanctioned, aided by the
They're
government.
getting grants. But that is the problem. If they've written the review application, see. See, termination was quashed to receive all arrear pay and benefits.
And then when we asked her to join, she resigned. And
She resigned, that's a different matter, but at least whatever is due to her should give.
Yes, my lord.
I have joined first, my lord.
No, you resigned, that's fine. That is why since you resigned, you hardly taught. You take instructions. She's not willing to relent.
My lord.
He wants to see them go to jail.
Let the property be auctioned, my lord.
What auction what?
That will be
Let the school be auctioned.
asking.
If
So
is
now,
that the case, my lord, all the children would come out.
then all the children, deprive all the children to education.
How can you auction the school? What to do?
Even if you auction the school,
How
2
will
lakhs
you
will not
delay
come
the
out.
review?
My lord, the delay.
775 days. And that also, my lord, they are very much aware that the money is, that they have to pay the money.
They are aware of that. That's why they
Ma'am.
come to review, Mr. Garcia. Otherwise they would have just kept silent. They're aware of that. And Mr. Yobin has fairly said that this is a mercy petition. This salary is from 13 to 26, 16.
My lord, my lord.
Termination 17.
My lord, may I?
My lord, if I may be allowed, can you come to para 24, page 24, my lord?
No, that I've seen. I'm at page 24 only.
My lord, yes, para 7, my lord.
Yes.
Mr. Suwansu, Learned Counsel for the respondent number 5, number 6.
No, that we know about that. It's not a question of everything they've done is illegal.
Yes.
The money you paid other teachers illegal also. They've used your money to pay another teacher because he never went to school. But the only thing that went against them, the way they terminated you was illegal. That's why the court had intervened. and asked for you to be reinstated.
My lord, may I request, because...
Okay, we'll admit the review for hearing then. We condone the delay. If you can't come to things, we'll have to hear it.
Because as far as I am concerned, my lord, we have a good ground for review also. Because that, the order, my lord, the inquiry order was in violation of the principle of natural justice, which was never brought to my lords when the lord, my lord, had passed
one
his
thing,
order.
Mr. Yuban, even entertaining your review would only be with regard to the amount of money.
My lord.
Otherwise, nothing new for review.
My lord, may
There are no new facts. The only new fact is that you can't pay this on.
My lord, may I request, my lord, because right now we are not sure, my lord, whether I'm not casting aspersions on my friend whether they're talking or not. But let there be a mediator, my lord. Let the officer from the education department. We will go together there in the project coordinator.
Mediation is only up to the petitioner. But there's nothing to decide anymore.
My lord.
That's the only thing. Only thing is that you can't pay, and to otherwise contempt will lie. Then you'll all go to jail. That's all. Contempt been filed by them.
And
you
while
file a review, which is hopefully time part number one, number two. So no new facts are there.
While pending this matter also, my lord, I have instructed them as much as you can, please try to. So far, my lord, off the record, my lord, 30,000 from the last day till now, they were able to collect 30,000 only, my lord. I was telling you, show your genuineness, try to collect some amount of money. At least I can show to the court what we are saying, we mean it. So till now, I've just spoken 30,000 they were able to collect.
You talk to your client.
Well, then let me
She's not
take
accepting.
again. That's the thing,
You take instructions again. We'll just hold the matter till after vacation.
After vacation, my lord.
Otherwise, we'll have to pass orders. We have no choice. At the prayer of the parties to try to resolve the matter, amicably list the matter after vacation.
28 also, my lord. All right.
Item number 8.
Lord, I have instruction to appear for the respondent in this case, my lord.
Respondent number?
1 and 2, my lord.
Sole respondent?
No, 1 and 2, my lord.
1 and?
2.
Mr. Judicial, is that the parents stood in behalf of 1 and 2? Such service complete. Yes, what do you want today?
Lord, copies to be served to me, my lord.
You don't serve copies?
Only through WhatsApp, my lord, but the annexures are not there, so...
You serve through WhatsApp now?
No, my lord. no, not that, my lord.
Yes, the petitioner will supply copies of the petition to the respondent list after applications for the orders. Are records necessary?
No, my lord.
Item number 9.
Yes.
The order has been complied with.
Just copy. Should I see copy of the order?
Is this the appointment letter?
The petitioner has been given appointment.
Yes. In view of the communication date 22nd November 2024, the orders of this court have substantially complied. Contempt only stands closed and disposed of.
Item number 10.
When was this filed? On the same day it was filed.
Please, Your Lordship, I'm supposed to file a rejoinder. I would need some time. Let it come after vacation, Lordship. A rejoinder to the state affidavit.
Yes, Mr. S. Marpan prays for further time to file the joint to the affidavit filed by state respondents 1, 2, 3. Just after vacation, yes.
Lordship.
11.
Wait, please, Your Lordship. Your Lordship, on behalf of respondent number 9, I'll be filing the affidavit in the course of the day.
No
You received the notice? Or you received the petition, the copy? No.
Not yet. I'll serve them, Your Lordship.
Yes, Ms. Rahman. Why? How many times you prayed?
After entering appearance is the third time.
Third time? Yes, MSZ Leconry submits that the affidavit in behalf of someone by course of the day. MS M. Rahman, for number 8, prays for further 2 weeks' time for affidavit. Yes, on so and so.
Obliged, Your Lordship.
12.
Lordship, I'm praying for some more time for filing rejoinder, Lordship.
How many times you prayed?
This is my second time, Lordship.
Yes, as prayed for the 2 weeks' time allowed for rejoinder.
12 and 14. 12 and 14 are same matter.
12 and 14?
14, yes.
Yes, after the motion.
13.
May it please Your Lordship. Your Lordship, in this matter, I'm supposed to file my rejoinder. Our rejoinders are ready, Your Lordship. It's just that we have not been able to acquire the signature of the petitioner. So will be filing during the course of the day, Your Lordship.
What, 1 to 4?
Lordship, we're only filing a rejoinder on behalf of respondents number 6 and 7.
The other ones you won't file?
The others I will not be filing, Lordship.
You won't file rejoinder number 5?
No, Lordship.
Mr. Yobin, 6 and 7. Only Mr. Yobin's
Yes, my
affidavit.
lord. Yes, Your Lordship.
Mrs. M. prays for the submits that the rejoinder would only be filed to the affidavit filed by respondents number
6 and 7.
Further submits that no rejoinder be filed to the affidavit filed by 8 to 10 whom?
Pro forma respondents, Lordship.
To the other affidavits, this certification.
Obliged. Highly obliged.
15.
Meanless submarine. Meanless, huh?
Lordship, here I am praying for some more time, my lord. Because we have received, recently we have received instructions from the Office of the Directorate, my lord. So if the matter is kindly taken up after vacation, my lord, in the meantime, my lord.
What's the matter of pension?
Lordship. My lord, his service is not regularized, my lord. It's not a regular
normal,
service.
not regularized, yes.
Is it similar situated
when
person?
were you appointed?
My lord,
similar situated person already 3 from this honorable court already they have been already regularized. In the,
No,
in the case,
when did you retire?
Retired Lordship.
Retired in?
On top of that, my lord, he is relying on this honorable court's order, my lord, which clearly says that it is not a precedent, my lord.
It's, my retirement Lordship is.
When did you retire?
I'm just saying Lordship. It is on 13/11/2023, I think you said. Your Lordship, we have directed this certificate to complete.
No, for a 2 week time granted to the respondent as well. Modified. Yes.
16.
Obliged, my lord.
2023, my lord.
What's blessed, Lordship?
Please, Your Lordship. Lordship, we have filed our wakalatnama on behalf of respondent number 5, 6 and 7.
5, 6, 7, you appeared since 20th.
20th, yes, Lordship. We have filed our power to do itself, Your Lordship.
You filing affidavit when?
After vacation, Your Lordship.
Yes.
I have already made a submission to the court, my lord. This is the second round of litigation, my lord. And our affidavit is a part of the petition, my lord. Because we are
Part of the petition?
My lord, yes, because the issue is with regard to conducting of VEC election, my lord. And in the first round, we have filed an affidavit stating that VEC, my lord, the constitution has already been made, my lord, election has already been conducted. So they have come back.
Now you are the president.
I'm the President Secretary.
So they're saying that the election was not done through a proper method.
Where's Mr. Sheikh? This is the one that you see is false case.
No, my lord, they're saying that the election wasn't done with proper channel, saying that there was no notification, all those issues, my lord. Our affidavit is
What
part
instructions do you have? Your affidavit says that, but your instructions say that everything was
It was
fine.
conducted, my lord. It was conducted through proper channel, my lord. We have brought all the list of the the members of the Employment Council, my lord, who have participated.
But you have not filed affidavit?
My lord, in the first round, we have filed an affidavit which is made part of the writ, my lord, here in the present case.
And what impugning a second petition? What's
Lordship,
your prayer?
Lordship, VC was conducted by Gram Sabha instead of conducted by village job card holders, Lordship.
It was, yes. What happened?
Lordship, VC was conducted by Gram Sabha instead of conducted by the job card holders, Lordship.
We'll dismiss this petition then.
My lord, my affidavit is at page 24, my lord, Annexure 8. We have brought the list of the entire signatories, the people, the members of...
Page 28.
Page 24, my lord, Annexure 8.
This is 23, this approval.
My lord, yes.
Page 24.
My lord, in the first round, their case was that no VEC has been formed, constituted. But we brought an affidavit that it has already been formed, my lord.
Mm.
So after we brought this affidavit, my lord, all the orders also, they have withdrawn that case and come back again saying that it was not constituted through proper channel.
Where's the Sheikh? He's not in town.
He's on leave, Lordship.
Okay. This is matter of the vacations for affidavits by respondents. Are you was here or you dismissed it?
Yes, Lordship.
If he was here, it would have been dismissed. Good, he's not here today. Yes.
May I please, Your Lordship? Your Lordship, in this matter, I am to pray some more time, Your Lordship, to
How
file
much time? How many times you prayed? Forgot how many times also.
What time, Your Lordship?
What's the matter about?
Lordship, demarcation, Lordship, I have one small
Demarcation?
prayer, Lordship. Lordship, since the adjacent landowners have again now disturbed my land, so Lordship, I humbly pray that status quo shall be maintained, Lordship, till demarcation is done. My prayer here is only for demarcation, Lordship.
Yes, Your Lordship.
You didn't file title suit?
No, Lordship.
You're trying to occupy land or disturbing your possession?
Disturbing, Lordship.
You're disturbing them or they're disturbing you?
They are disturbing me, Lordship.
Your Lordship, they haven't made
You have
the
not
party.
appeared, you have not made them party.
Your
No,
Lordship.
Lordship,
Why?
because Lordship, the
Then we
authority
can't-
here
how
to
will you bind
demarcate
them?
is the district council, so
Then we can't bind them, you make them party. MS Mathur submits that, oh no, first MS and Raji praises Shulat for that time behalf respondents 124 to file affidavit stuff. It was submitted by MS D Mathur that some interim protection is necessary as her neighbors, sorry, demarcations being as much her neighbors in the adjoining land from which demarcation is being sought are disturbing her possession. This court notes, however, that the adjoining landowners have not been made party before this court. MS the petitioner is permitted to implead necessary party. So we can't pass orders otherwise, just after vacation.
Obliged,
Implead them, then how do you bind them?
18.
Yeah.
Please, Your Lordship, I'm filing during the course of the day because there's a mistake in the...
You receive copy? Yes. As well as Haji Leonard G. submits that the absolute ban calls the day. This is matter after vacations for rejoinder of any.
Much obliged.
19.
We're awaiting instructions.
Milords, the status of service on respondents 6 and 7 is, Milords, that we are still awaiting service report.
What about 6? 606.
6 is, I think, managing committee.
6
6 is probably the managing
6
committee.
is the managing committee, Milords.
Oh, you're the private responsible. You're a teacher, other teacher. Mr. MSP was for Karmas and appearance to behalf number 7. However, a state of service on respondent number 6 is not yet received. What do you want today?
Milords, a week's time, Milords, within, I think by then we'll be able to. Milords, may permit us to also serve Dasti, since there's the managing committee.
Yes, Mr. K. Paul submits saying without to effect personal service on the respondent number 6, praise allowed. List of applications.
Milords, interim orders are there, Milords.
Interim orders?
Milords.
Status quo, my lord. No, my lord, only
Status quo is an interim order, Milords. I don't think it's a
No,
final
Lord,
order.
We have already, of course, verbal instructions we have received, my lord.
They yet to file any counter
No, there is
affidavit.
no violation as such. This, rather, my lord, this writ petition is filed premature. Because I have taken instructions, my lord, verbally. No such order has been passed as yet.
Let my learned friend file a counter affidavit. Your lordships will hear the matter. Till then, the interim orders have to continue.
The order of this honorable court only says status quo, my lord.
Yes. List of applications, interim orders continue meanwhile.
Obliged.
Contempt?
Is that notice issue, my lords? Your lordships will hear the matter as and when.
Notice but that if there's no contempt in the phase of the court, we'll keep it pending.
Lordships
We'll list together with the main case.
Obliged. Obliged, my lord.
20.
I need some more time. Like this. Lordship will need some more time in this matter.
What matter about?
This pertains to the service of these petitioners, my lords, who were earlier regularized. Subsequently, my lords, there was an office memorandum by which they were shown to be regularized this year.
Oh, okay.
Confirmed and regularized.
Lordship, we need some more time, your lordship. We come after vacation, your lordship.
Already confirmed in 2019.
My lords.
Yes, sir, Mr. Andy Shulai and NDG praise for particular file affidavit. Yes, there are.
Apply. 20 to 24, your
20 to 24 connected matters.
Apply, your lordship.
25.
Lordship, this connected matter is listed day after tomorrow.
What connected matter?
This is that regarding admission into PIMC, Your Lordship.
Those,
oh, okay.
So if this matter is taken up day after tomorrow, Your Lordship, because we would like to bring on record some more developments. Obliged, Lordship.
For the 13th student, I believe Lordship has given the status quo. Maybe for that,
So
I think.
it's that connected matters listed day after he plays that incident matter listed along with the other matters praise allowed. Affidavit has been filed by the responding number
678.
678 today. CM taken on record. List accordingly and so on.
But I'm only appearing for respondent number 1. National Medical Commission is also respondent number 1. The last order is reflected that I appeared for 1. You want to take steps on
Yes, next take down like Ms. Dr. Muzika has also submitted that they are in fact appearing respondent number 1. So, if that be the case, then it's pressure to take steps to respondent number 2. Yes.
Obliged.
Hearing 26.
What has happened to Supreme Court?
Yes, my lord, I've taken instructions. My lord, what is pending in the Supreme Court is a writ petition number 1022 of 1989.
1989?
Yes, my lord. This is that Judges Association case, my lord. So, Lordship is well aware, it keeps getting reported from time to time. So, my lord, this writ petition is purely related to the service conditions of judicial officers, my lord, judges. And it's pending for so long for the simple reason that whenever a new pay commission comes up, etc., there are changes. Now, in this writ petition, my lord, there were few interlocutory applications filed by the Association of Judicial Staff, All India Confederation of Judicial Staff. They filed
a different IA here.
A different IA in that writ petition.
Exactly, 1022.
Yes, my lord. Yes. Now that IA,
IA number?
IA, there were several, my lord. 71A.
Yeah.
Lordship, if Lordship looks at page 61, it's there, my lord.
Of the writ petition.
Of the writ petition.
Who is appearing for the state? Mr. Shulai.
Oh, Your Lordship, the AG is leading this matter.
How many lawyers are appearing? Mr. Shulai is not there. I thought Mr. Shulai was here. No.
No, Your Lordship.
Page 61, my lord. Page 61, it's a record of proceeding from Supreme Court, my lord. The IA numbers are mentioned on top, my lord. There are several IA numbers in WPC number 1022, 1989. Yes. Lordship looks at the first party itself, becomes clear. Yeah, first party is All India Judicial Employees Confederation, my lord. Now this IA, my lord,
IA number
71A, 135 to 36, yes. 37 to 38, so on. This IA, my lord, if Lordship looks at page 66, has been disposed of. All these IAs.
All in there's the association.
Yes.
All Institute Employees Confederation.
Yes, my lord.
But it's only Bihar state. No.
Yes, my lord. But the directions in the IA is important. If Lordship looks at page 66, 66. A very short order, my lord. I'll read, my lord. Page 66, implement applications are allowed. Shetty Commission report was submitted in March 2003 pursuant to the orders dated so-and-so and so-and-so passed by this court, wherein it was emphasized that the improvement in service conditions of the judicial staff is necessary for the administration of justice and rule of law. This court, after considering the submissions made by the states, UTs, high courts, has accepted the Shetty Commission recommendations and passed various orders. Finally, on so-and-so, this court has directed recommendations are reasonable and do not involve any financial burden. The decision to implement the recommendations by all states should be taken within a period of 3 months. The recommendations will be implemented with effect from 1/4/2003. We are told that so far these states, UTs, have not implemented the recommendations fully. Some of the states have implemented the recommendations but had given effect to the dates later than so-and-so. Still, some of the grievances of various offices are subsisting. In view of these circumstances, we direct that hereafter these matters be considered by the respective high courts of the states, UTs. We direct that High Court, number one, High Courts on judicial administrative side will ensure implementation of the recommendations of the Shetty Commission within a reasonable period of 1 year. The High Court shall permit writ petitions or applications that may be filed by the individual or staff association representing the various members of the staff. Number two, High Court shall also see that the recommendations are implemented with effect from so-and-so. Number three, there shall be benefit of, it goes on, my lord. At the end, my lord, next page, IAs are disposed of accordingly. So, my lord, the staff had implemented themselves before the Supreme Court through certain IAs. IAs were disposed of with these directions that thereafter the Honorable High Courts all over the country will take up the issue of staff service conditions. So, based on the liberty extended by the High Court, today's petitioner has come before this Honorable Court. So,
and why was the submission being made repeatedly that the matters are pending consideration?
I cannot speak on that, my lord. I cannot speak on that, but
yes, I was Tunga.
Lordship, I was just instructed by one of my colleagues that there is a matter pending before the Apex Court, and Lordship, I have a copy of it. It is also similarly titled, Lordship, All India Judges Association versus Union of India, writ appeal number 643 of 2015.
Writ appeal?
Yes, Your Lordship, writ petition number 643 of 2015 in the Apex Court. Lordship, I'm told that there are some similar connected issues involved.
Lordship, that is pending, my lord. I have no dispute.
What is that?
That is the same Judges Association.
No. Regarding this particular direction of the Supreme Court.
Lordship, it's still pending before the Apex Court.
Lordship, I would submit that this is the same Judges Association matter concerning service conditions of judicial officers, judges, my lord. This IA order, my lord, this order which I've just read out.
But it's a different writ petition.
It's a different writ petition. But my humble submission would be that Supreme Court was very clear when disposing of the IAs that thereafter any matter concerning service conditions of staff.
The AG is not here. How are you going to? Yes, Mr. S. Jindal has shown before the court that the matter concerning the petition can go forward on the basis of the orders passed by the Supreme Court itself in several I-stop A's,
Lordship,
especially order dated
7/10/2009.
7/10/2009. Due to the absence of Advocate General, this is a matter of publications. Yes.
Next.
29.
Yes. Who's there for union? The same on that subsidy.
By the way, this is a matter which you heard on the transport subsidy, you know.
Asam, you're not there.
Well, I was not there last time.
You're not there, no?
The sole ground which I was raising before Lordship that matter.
Yes.
Before the sole ground which I raised before Lordship was that the transport subsidy which I was entitled to was short paid prior to issuance of the clarification which has subsequently also withdrawn. Thereafter, the state of Meghalaya is regularly writing to the central government for giving a clarification in the matter, and the clarification is not being given.
Yes,
At
yes,
this
yes.
stage, at this stage, I am only praying that the action may be issued for issuance of the clarification, and thereafter, if the clarification comes against me, if it comes in favor of me, there will nothing remain.
Yeah.
And if it comes against me, then I can challenge it without the clarification.
Yes. How soon can you give, Dr. Mozika? Clarification?
Well, in my humble submission, clarification is not required at this time, my lord.
Why?
Because why, my lord, firstly, what we have said, my lord, the claim period, they
Advocate
come.
General is here. I thought that you were in Delhi. Where's the note? The shortfall 4 crores.
My lord.
Yes.
My lord, our first submission is that the claim period is of 2013, my lord. And they filed the present writ petition in the year 23. There's a delay of 10 years, my lord.
Yes.
That is our first submission, my lord.
Yes.
And the second submission is, if Lordship kindly turns to page 21 of my affidavit, my lord.
21.
21. Now, my lord, this is dated 4th of July 2014. Their claim arises out of this, my lord.
Yes.
Now, but the same order, my lord, at page 22, para 5, will also kindly see. It has been also been decided claims which have already been settled need not be reconsidered, reopened. So now, either they accept this entire order in entirety, my lord, or they reject it. Now they want to take benefit out of this, my lord, but they want to ignore para 5 of this, my lord.
Yes. Yes, this is a modification in issue 2.
My lord, their claim arises from this, my lord.
Yes.
Because by this order, by this office memorandum, it was decided in para 3, if Lordship kindly sees, my lord. In fact, from para 2, my lord. The cause of action arises from this office memorandum.
Yes.
Para 2 onwards, my lord. The matter has been examined in this department in consultation with the Integrated Finance Wing and the Office of the Chief Controller of Accounts, DIPP. And after careful examination, it has now been clarified that in case of interstate movement of finished goods within the NER, the cost of transportation beyond the railway head nearest to the delivery point where finished goods is being delivered is also to be taken into account for subsidy under Transport Subsidy Scheme 1971. In such cases, the actual cost of transportation or the cost of movement from the location of the industrial unit to the nearest railway station by road and thereafter by rail to the railway station nearest to the location where the finished goods is to be received and subsequently by road from that railway station to the location where finished goods has been received, whichever will be taken into account.
Yes.
Accordingly, this department's earlier letter of even number dated so and so stands withdrawn. But then it puts a caveat, my lord. It has also
when was this claim settled? The claims of petitioner?
That you also will find is page 23, my lord.
Of your affidavit.
13th September 2013. Page 35 of the writ petition, Lord.
Page 23 of the affidavit, and the same document is the next one.
Okay.
Prior to issuance of the circular.
Now, Mr. Saraf, only one thing, Dr. Saraf. After this 2014, when did you pursue the matter independently, or you didn't do anything? You came to court after 10 years.
No. I was taking up the matter regularly with Your Excellency at in 2016 at page 42.
Of your petition.
My lord.
But even then, that's 2 years.
No, thereafter again, my lord, the letter of 19 was there from the state government to the central government. There was no clarification. Then again in 21, I wrote a letter. Then again the Meghalaya government wrote again a letter in 21 to the government of India. No reply. It was going on.
Well, they have not pursued the matter. Meghalaya government writing one letter.
No, we
will not extend the limitation, my lord. Will not extend the limitation, my lord. Now, page 23, I'll just point out, my lord.
Yes.
In my affidavit. Now, these are the minutes of the 78th meeting of the States Level Committee for consideration of claims under the central subsidies so-and-so held on 12th and 13th of September 2013. Now, at page 36, your lordship will find at serial number 9, page 36.
Yes.
Now, this is how, because this committee sits and considers all the similar cases, my lord. The Adhunik Cements case, the petitioner's case is at serial number 9. Adhunik Cement Limited for the period so-and-so.
Adhunik was bought by Dalmia.
By Dalmia. So that is how the cause of action, if any, arises at that point of time, my lord. But at that point of time, there was old circulars were applicable. Now, new circular comes in 2014, my lord. After this has been sanctioned, they received.
What does it say? Number 9.
At page 37, just before claim period, well, as in the case of Mega Technical, if I was. Page 37.
Yes.
As in the case of Mega Technical Engineers Private Limited, the committee decided that the transport cost from the next railway station nearest to the destination by road should not be taken into account pending clarification of the government. The committee also, after taking this decision, examined and cross-checked the claim and found that the unit is eligible for the above claims since the claims are in conformity with the prescribed checklist. The following decisions were then taken. And for various periods, my lord, it was rejected after that, my lord. And this was not a singular case of this particular petitioner, my lord. This was identical, similar treatment was given to all the companies, my lord. Lordship will see JUD Cement is also covered here.
Which one?
At page 36, my lord.
Yes.
Then Mega Technical at page 28. So several companies were covered, were considered and decided in this particular meeting of the state level committee, my lord.
Yes.
So, my lord, there are my twofold submission, my lord, that there is a delay in latches of about 10 years.
Yeah.
Even otherwise, the last letter which they have annexed is of 2016, my lord. Even after that, my lord, there is no explanation of for 7 years delay. That's first submission, my lord. And second submission is that circular of January 2014, which gives them the, if any cause of action, my lord. That itself, in para 5 says that.
You can't blow hot and cold, you mean?
My lord, that is our submission, my lord. And third submission would be, my lord, the state government writing one letter for clarification to central government. That will not extend the limitation, my lord.
So according to you, on your submission, the no clarification necessary.
No,
they are
no.
bound by 2014 letter, and they've already availed of advance subsidy, which gives them point to point, not station to station. That's it.
My lord.
Yes.
My lord.
Kindly see state's brief reply, my lord.
Yes.
My affidavit is there, my lord, and even your lordship kindly see the annexure 3 of the writ petition, my lord. 3 of the.
Your respondent number?
I am respondent number, my lord.
Yes, okay. 113, right.
Respondent 3, my lord.
Yes.
Your lordship kindly see the annexure 3 at page 38, my lord.
Of your affidavit?
Yes, my lord, and your lordship again central government on 4th page 38, my lord.
Of your affidavit?
Of the writ petition, my lord, writ petition itself. Page 38, my lord, and the
yes.
Nature of a scheme and discussion has been made, my lord. This letter is relevant. The undersigned is directed to invite the reference of notification dated 24th May 1988, thereby amending paragraphs 1 of the order dated 17th March 1987 and allowing transport subsidy on interstate movement of finished goods within northeastern region, and to say that the internal audit wing of this department, while conducting post-audit transport subsidy claims in the state of Meghalaya, has pointed out in its report that subsidy has been allowed on transportation of cost of finished goods beyond the railhead of another state for interstate movement of finished goods within northeastern region, which is not permissible. My lord, kindly mark the case-wise details of excess payment of subsidy pointed out by internal wing of the department is as under. So initially also, my lord, for interstate movement, the subsidy was not permissible, and the audit has asked for recovery, my lord. Now, paragraph 2. Internal Audit Wing has also recommended that Director of Industries, Government of Meghalaya, may carry out a review of all such transactions, subsidy claims, and excess subsidy paid earlier may be recovered from the industrial unit immediately. Accordingly, it is requested that the Government of Meghalaya may take appropriate action in this regard. 3. My lord, in view of the above, it is clarified that as per provisions of Transport Subsidy Scheme 1971, subsidy is not admissible for the transportation costs incurred for interstate movement of finished goods within northeastern states beyond the railway.
This was withdrawn.
So, my lord, therefore, this order was passed on, my lord, kindly see 4th October 2013, my lord, saying that it is not admissible. Writ has been filed in 2013, my lord. 23, sorry. It has been filed in.
One thing, but this notification has been withdrawn.
No, my lord, this notification has, if your lordship will see, the first paragraph, in the first paragraph itself, it is stated, my lord, the transport subsidy for interstate movement of finished goods within northeastern region is to be restricted up to railway station nearest to the point of delivery, my lord. So, and what the subsidy which is being claimed here before your lordship by way of writ petition is subsidy towards interstate movement. That subsidy is not admissible under the scheme, my lord. And
No, see, this is withdrawn. This annexure 3 is since withdrawn.
No, your lordship.
Come to annexure 4, paragraph 4.
Yes, my lord.
Page
4.
41.
Yes, accordingly, department even number dated stands withdrawn with respect to, my lord, recovery, my lord. Your lordship will find the recovery, so far as this part is concerned, paragraph 3, my lord.
Read paragraph 3.
Yes, my lord. In such cases, the actual cost of transportation or the cost of movement from location of industrial unit to the nearest railway station by road and thereafter by rail to the railway station need to the nearest to the location where the finished good is to be received and subsequently by road from the railway station to location where finished goods has been received, whichever is less will be taken into account. So, interstate movement of the goods, my lord, that is not exempted, and that part has again clarified, my lord. And lastly, my lord, your lordship, once judgment of the Supreme Court by filing representation, limitation cannot be extended, my lord. To 2022 15 SEC 536, my lord. Lordship, it's a very short judgment. Feeling aggrieved and dissatisfied with the impugned judgment and order of 21 passed by the High Court of Judicature, Allahabad, High Court has dismissed the said representation preferred by petitioner. Herein, original representation has preferred present special petition. Facts leading to present special petition in nutshell is that petitioner entered into cell deed with the respondent Noida, white cell deed dated 19/9/2001, whereby petitioner sold plot number so and so. Lordship, kindly note the period. And 2.2. After period of 10 years from the date of execution of sale deed, petitioner made a representation to Noida by representation dated 10/3 requesting to allot a plot as agreed in terms of sale deed. Now 2.3, my lord. The thereafter by the order dated 23/5/2017, Noida rejected the said representation. Feeling aggrieved and dissatisfied with the order of Noida, writ petition was filed, my lord. Now kindly see paragraph 4, my lord. At the outset, it is required to be noted by way of writ petition under Article 226 of Constitution of India, as such petitioner prayed for a specific performance of clause 12 of sale deed. For the first time, petitioner made a representation for allotment in 10% in 2001. In the year 2000 and in the year 2000 after 10 years from the date of execution. Therefore, as such, if the suit would have been filed for a specific performance, the same would have been barred by limitation. Despite the above, petitioner filed a writ petition before the High Court as and observed here for a specific performance of clause so and so of dated so and so after period of 11 years, my lord. 6. The High Court, by passing the order dated 7th April 2017, as such did not realize or appreciated that writ petition itself was required to be dismissed on the ground of delay and laches as the same was filed after 11 years from the date of execution of sale deed under the right of claim. We have come across a number of such orders passed by the High Court directing the authorities to decide the representation through the representations are made belatedly, and thereafter when a decision is taken on such representation, thereafter it can be said on behalf of petitioner that the fresh cause of action has arisen on rejection of the representation. Therefore, when such orders are passed by the High Court, either relegating the petitioner to make a representation and or directing the appropriate authority to decide the representation, High Court have to consider whether writ petition is filed belatedly and or same is barred by laches and or not. In the future, the person who has approached belatedly may not contend that fresh cause of action has arisen on the rejection of representation. Even in a case where earlier representation is rejected, the High Court shall decide the matter on merits. As observed by this court in catena of decisions, mere representation does not extend the period of limitation.
Everything depends on case to case anyway.
Your Lordship, the representations will not extend, that's a settled law, my Lord. So far as representation will not extend, my Lord. That limitation, that paragraph 8 is very clear, my Lord. That, and I have other authorities also, representation will not, because that decision was taken way back in 2014, my Lord, and after 10 years, it is clearly barred by delay and laches, my Lord, and the principle is settled.
So that one point regarding, you say the 2014 notification, which recalls that 4th October 2013, you say that it only with regard to that aspect.
Yes, my Lord, that is also
point,
clear
but
from
it restores a point to point.
Yes.
Point to, so there's no question of overdrawing, I mean, of overbilling or something, if that position is maintained.
Because if under
point to point, see, the thing is that 13 says that you have been getting excess payment because you charge point to point, correct?
Yeah, if you Lordship
and then
will see,
by 14 it corrected, so okay, fine, from it has to be from the
rail head to
by road from that railway station location where you receive, so whichever is less, so they have corrected that, and so that means that whatever payments have excess, there's no question excess payment anymore. Now what they're saying really that they have, like, since the policy has been reviewed and that October 4th October
2014, my lord.
Recall. So that's the only cause of action that pay me the shortfall
therefore,
of 4 crores.
Yes, my lord, and that cause of action arose way back in
That's your case.
2014, my lord. Even assuming that cause of action, my lord, that will the delay is unexplained delay on basis of representation. It cannot be extended, my lord. And moreover, because ultimately the clarification also, my lord, it says that nearest railhead by road and thereafter rail to railway station, my lord. So those are factual details. Writ court may not go into those aspects also.
We'll pass orders then, Dr. Saraf.
But I will just, if you also permit me, I will
Yes,
take
of course.
5 minutes only. But your lordship, can I see page 35?
Of your writ petition.
My lord.
Yes.
I was short paid prior to issuance of the notification dated 4th October 2013.
Yes.
It is not so that after 4th October payment was made.
No, that's fine. That's fine. What?
No.
See, what is fine? Only
No,
that's all right.
Now, the learned AG was submitting that interested movement, the transport subsidy was not eligible. Your lordship, can you see, my lord, what was not eligible? My lord, the earlier they clarified that from the industrial unit to the railway head, the transport subsidy will not be eligible. Interstate movement, there is no dispute at all.
Yes.
From the, if you lordship, just see, my lord, the paragraph 1 of page 40.
Page
40, my lord, of the petition.
Yes.
I just one paragraph, my lord.
Yes.
The undersigned is directed to invite reference to the notification number so-and-so, whereby amending so-and-so and allowing transport subsidy on interstate movement of finished goods within Northeastern region, also to the department letter wherein it has been clarified that as per the provision of transport subsidy scheme, subsidy is not admissible for the transportation cost incurred for interstate movement of finished goods within Northeastern states beyond the railway station nearest to the final destination. So the only restriction was that from railway station to
understood, sir. For what happened, they corrected me as point to point, not from railway station to railway station. That's all, yes.
That was the earlier view, but it was said that now it will be entitled to.
Yeah, now point to point.
Now the
Understood, yes.
Placed before lordship the judgment of the apex court, there the first representation was submitted after 10 years. Your lordship, can you see the judgment which was placed before lordship, the Supreme Court? In that, the first representation was submitted after 10 years. And after rejection of the same, he went to the High Court, 226. Now, in this case, my case, my lord, the first representation was submitted in 2016. Your lordship, see page 42.
Yes.
The first representation of mine was submitted in the year 2016.
Yes.
And in 2019, my lord, the Director of Industries wrote to the Union Under Secretary to clarify the matter.
Yes.
Thereafter, again in 2021, again I wrote a letter reminding it, and again the Director of Industries in 2021 wrote a letter to the Under Secretary for clarifying.
Yeah.
Again, my lord, you lost your fine. Another letter in February 2021 at page 51, again a reminder by the Director of Industries. Now again, I wrote a letter to the Government of India also at page 53 in 22. So it is not a case that I was sleeping over the matter for 10 years and I submitted a petition and thereafter, my lord, it was done. Now, further submit, my lord, the learned AG is appearing for the state of Meghalaya. This subsidy is of transport subsidy, which is of the Union of India.
I'm assisting
state. No, I am just submitting. I am not opposing that your appearance. Nowhere. I will never oppose.
And he is responding. He is not petitioning.
I'm assisting the court.
And I will never oppose. In fact, the AG should support me because the industrial unit in the state of Meghalaya, they should get the transport subsidy that is in the interest of the state of Meghalaya. The state of Meghalaya should never oppose. The question is that
we have to go by
no, I'm not.
Whatever is in the scheme is there, whatever is there.
Yes.
I always, nobody is going beyond law, my lord. What I was submitting, my lord, that the main respondent is Mr. Mujika, who is appearing, and his only argument is that, my lord, the belated, when the state of Meghalaya is taking up the matter with the Government of India, for clarification, they are not issuing the clarification from 2019. And the Supreme Court judgment which Mr. Learned AG placed below, there the representation itself was submitted after 10 years. And the Supreme Court said that you cannot submit a representation after 10 years. And thereafter say the cause of action has arisen. In this case, the representation, the claim was made in 2019 itself, 16 itself. So, in my humble submission, that judgment has no application at all. It has to be on the facts of each case.
Yes.
And, that is my humble submission, my Lord.
Only one point I wanted to. In my affidavit, I've said that when the money was paid, my Lord. At page 12 of my affidavit.
Government of India is by hook and crook, my Lord, trying to see that they should not get the money. They should not announce the schemes.
Saraf is getting angry.
Yes.
No, why I should be angry?
No, yes.
At page 12 of my affidavit, my Lord.
See, Dr. Saraf is a passionate lawyer. No question of anger. Yes. Yes.
Page 12, my Lord. I'll just, second sub-para. However, against the above directive, several representations, I can skip this next para. Since the claim of the petitioner has been approved.
Can you read it?
Yes.
Read it.
No problem. Please go ahead.
Why you are skipping over?
Yes.
Since the claim of the petition has been approved earlier by 70th State Level Committee held on 13/9/13, and all the claims of the petitioner's company were also disbursed by the net fee before the later dated 14/7/2014.
Yes.
Hence, the claim are to be treated as already been settled, and therefore reopening of the petitioner claim does not arise. And the date of funds sanctioned by DPIT, Lord Civils, in the last column.
Yes.
These are all before the 2014 circular, my Lord.
Before the?
Well, only one second.
I'll just complete.
Yes.
So, the circular is dated 4th of July 2014, my Lord. And the last.
The one who were drawing that 13 notification. Yes.
So, my Lord, all the money was disbursed to them before the 2014 circular was issued. So
that means,
the
Doctor,
claims were settled
that
claims.
means this petition to take civil law remedy for recovery of the other amounts.
My Lord, that was my another limb of argument, my Lord. What they cannot enforce by way of civil suit, my Lord.
No. But to the sanction of the court is that there's a shortfall. There's a shortfall of 4 crores as all. And they have been paid. It's not a question they have not been paid. They have been paid, but the short 4 crores, which they say an admitted amount. Since admitted amount under the subsidy scheme, so they entitled to it they can come by 226. Since it's not an undisputed amount. But now your submissions are otherwise. So anyway.
But otherwise also what is not permitted under civil law, my Lord, the limitation period is 3 years. Here is a clearly time barred otherwise also, my Lord. So 226 cannot be used, my Lord, to subvert or bypass limitation under the civil law.
The 226 has no limitations. 226 is to be used for wiping out the tears of poor litigants. You'll also make you aware. Now,
I don't know about whether litigants poor, but you know.
Well, in comparison to the union, it is poor litigant. One sentence only, my Lord, I will.
Yes.
My Lord, the second notification of the Government of India, which says that claims which have already been settled should not be reopened, is on the basis that after the issuance of the first notification, if any claim has been settled, that should be reopened, not reopened. My claim was not after the first notification. My claim was prior to the issuance of the notification. So that observation on the second notification will not come into operation in the case of mine, my Lord. That is my humble submission. And you'll also be aware, my Lord, when the admitted amounts are there, the 226, you'll also be always directing the state also to make payment of the same. Here the question of admitted amount, they are not disputing the amount at all.
The shortfall? You're not disputing the shortfall of 4 crores.
They are not
We have not even gone into examining that matter. We have not even examined. We have said that this is clearly time barred.
Settled.
Yes.
Anywhere, my Lord, they have not said in the affidavit that this amount they are not entitled.
Dr. Saraf, there's no question of this court issuing a mandamus for payment.
I'm not.
At this
I'm
stage,
not
no.
saying no.
The only mandamus you're seeking is that clarify the position of the union as to whether they're entitled or
No,
not.
I'm not. In this
And you take it from there.
Well, this is a circuitous route to
reviving
to revive the limitation, my Lord.
Well, I have not.
It's like
well, that is your
flogging a
ultimate
dead
fee.
horse, my Lord.
No, your ultimate see the petitions. He is saying 11-12. Matters are pending from 60-61 years. The years, the assessment year or year is not has no value. One cannot say that this is matter relating to 11-12. How 11-12 if you don't pay me? What I can do? Whether they have paid the subsidy of the other persons in time, 10 years they have not paid. Where he should go?
Right.
One cannot say that, no, this is 11-12. What 11-12 matters are pending for 55-56 also. As you are aware, in the chart I was seeing, in Supreme Court, one matter is pending of year 55-56 also. So that cannot be said that this is relating to 11-12, so the matters will be closed. If that is so, all matters will be closed.
Right, okay, we'll pass orders.
Judgment reserve.
We won't reserve, we'll pass today itself. Yes. Yes.
I'm highly obliged. I'm highly obliged.
You have the spirit of Dr. Sarab.
Judge.
Every case is a